We live. Shout out to Pittsburgh. Shout out to Pittsburgh. Make sure you subscribe to the channel and share this video with whoever you have been discussing the Puffy trial with. You may be discussing it, arguing about it, whatever you're doing with it. Share this video. Whatever you're doing with it, just make sure you share this video. We locked in. We locked in. Share this video. All right. So, what I have here are two documents that I'm going to be going over. I'm down here. I'm in downtown Pittsburgh. I'm in downtown Pittsburgh at the train station. So here we have first, we're going to go over this. This is a 133-page document. We're going to go over this, but not right now. The document that we're going to cover right now, I've covered it a little bit already when I was in Philadelphia. This is the 182-page document. This is 182 pages. This is the sentencing memorandum, okay, on behalf of Sean Combs, submitted by his lawyers, okay? Mark Agnifilo, Tenny Garagos, Alexander Shapiro, Jason Driscoll, Brian Steele, Nicole Westmoreland, Xavier Donaldson, and Anna Estevella. Now, what I want to talk about is the prosecutorial misconduct that continues to be practiced by the Southern District of New York. Okay? Now, Amendment 826, go and look that up. Federal Amendment 826. And in the Federal Amendment 826, you will see that in November of 2024, the United States Sentencing Commission put into law that acquitted conduct for which you were charged, went to trial, and found innocent of can no longer be used to calculate your sentencing guidelines. It used to be, before November 2024, that when a person went to trial, if you went to trial or I went to trial and we were charged with grand theft auto, we were charged with stealing a candy bar, we were charged with tax evasion, we were charged with wire fraud. Prior to November 2024, say we got convicted of stealing a candy bar, but we got acquitted of grand theft auto, acquitted of tax evasion, and acquitted of wire fraud. Before November 2024, when they were calculating your sentence for stealing the candy bar for which you were found guilty, the probation department and the prosecution was allowed to use as relevant conduct to determine your base offense level, ultimately how much time you were spent in prison, the other charges that you were acquitted for, that you were acquitted of, the grand theft auto, the tax evasion, and the bank fraud. But they voted into law saying that that's not fair, right? That a defendant should only be, his guideline range and his sentencing should only be for the charge and the counts that he was found guilty of, right? So in this instance, it would just be for stealing a candy bar. And wherever that falls on the guideline range, that is it. Now, what happened at the trial, Puffy was charged with racketeering conspiracy. In the racketeering conspiracy, underneath the umbrella was racketeering conspiracy. Under the racketeering conspiracy, there were predicate offenses. Some of the predicate offenses were bribery, arson, kidnapping, sex trafficking, force, coercion, possession with the intent to distribute drugs, prostitution, violence. And look at that picture right there. All the prosecution needed to do to be successful in convicting Puffy of racketeering conspiracy was to find that he committed 2 of those predicate offenses. Fraud was another one. Fraud, force, coercion, right? There was like 10 or 11 predicate offenses. The jury acquitted Puffy of racketeering conspiracy. The Southern District of New York knows this because they got beat. They lost. Maureen Comey, Smizer, Damian Williams, Reddick, Johnson, Steiner, all of the assistant U.S. attorneys, the Southern District of New York, they got beat. They lost in epic proportions. This is not a win for the Southern District of New York. This is a loss. What they really wanted was the racketeering conspiracy and the sex trafficking so that they could activate the asset forfeiture clause and seize Puffy's money, his bank accounts, his real estate, his catalog, his assets, anything that he owned, the plane, they were gonna take. But they got beat. They lost. It was a huge defeat to the Southern District of New York. And the Southern District of New York got exposed as an organization that is open to prosecutorial misconduct, right? The Southern District of New York got exposed that they will cheat. The Southern District of New York got exposed to that how many other men have been falsely convicted by the Southern District of New York because of their unscrupulous conduct, their prosecutorial misconduct, their lies. They're putting witnesses on the stand that committed perjury, that they knew were going to perjure themselves before they put them on the stand. The prosecutorial misconduct was so rampant in this case that it shocked me. It shocked me because here I'm thinking that the feds are the ultimate professionals, that their research and their evidence collection is so solid and so tight, and that their assistant U.S. attorneys are Ivy League graduates, that they don't need to cheat. They don't need to circumvent the law to win. That when the feds come, they got it. And that you might as well just forget it and give up. That was the impression that I had. The picture just flew over. But after going to the trial, after sitting in the courtroom, day after day after day, after reading all of the filings by Alexander Shapiro, where Alexander Shapiro detailed the prosecutorial misconduct that took place before the trial even started. The Southern District of New York allowed mainstream media and leaked information to mainstream media to poison the jury pool, to destroy Puffy's name in the public, as far as public opinion. The Southern District of New York prosecutors under Maureen Comey went into Puffy's cell and took pictures of his legal notes that he wrote down in conferences with his attorneys outlining his defense strategy. The COs at MDC Brooklyn shook down the prison. The COs at MDC Brooklyn shook down. If you don't know what a shakedown is, if you've never been to prison, a shakedown is when the warden tells all of the COs and all of the guards to tell all the prisoners to freeze, come out of your cell, stand over there, and COs go into your cell and they rip your cell apart looking for contraband, knives, drugs, weapons, food, phones, alcohol, stingers, That's called a shakedown. The Southern District of New York ordered a shakedown of MDC Brooklyn, and during the shakedown, they found nothing during the shakedown. The COs at MDC Brooklyn called over to the Southern District of New York and says, we shook it down. The Southern District of New York told them, go in Puffy's cell and shake down Puffy's cell and take pictures of whatever notes, anything of import that you see, take pictures. The COs, following the instructions of Maureen Comey, Damian Williams, Steiner, Johnson, Reddick, Slavic, went into Puffy's cell and started to take pictures. Click, 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 of his defense strategy that he wrote down, the notes he took when he was meeting with Mark Agnifilo, when he was meeting with Tenny Garagos, when he was meeting with Xavier Donaldson, when he was meeting with Nicole Westmoreland, when he was meeting with Brian Steele, Anna Esteveyo, Alexandra Shapiro. And they took those pictures, the COs, and sent those pictures back to the Southern District of New York, which is a willful violation of Puffy's attorney-client privilege and his right to privacy. All of this is documented. This is before the trial. This is what the Southern District of New York engaged in. These are the actions that they engaged in before the trial. The Southern District of New York used 7 of their 9 peremptory challenges or peremptory strikes to strike 7 black jurors from the jury pool. "72% of 72 or 82, 10% of 9 would be 0.9, 0.18, 72%. 82% of their peremptory strikes were used to strike black jurors. The Southern District of New York had a black juror removed from the jury in week 6. That didn't work. The Southern District of New York took a civil suit filed by Douglas Wigdor, the Wigdor law firm, Doug Wigdor of the Wigdor law firm engaged in attorney misconduct by filing a federal complaint in the court of law that he knew or should have known was full of perjury, misrepresentations, and flat out lies. But he did it anyway. I need everybody to send an email and report Douglas Wigdor of the Wigdor Law Firm in New York City, WIGDOR, report him and his law firm to the New York State Bar Association for attorney misconduct for filing a willfully negligent civil suit in federal court full of perjury, full of lies that either he knew or should have known. I need all of y'all to do that tonight. This was Cassie's lawyer. That lawsuit that Doug Wigdor filed was the foundation, was the underpinning of the criminal case. And Maureen Comey and the other five, Maureen Comey, Emily Johnson, Steiner, Slavic, Reddick, and Smizer, they might be the same people, took that lawsuit. Damian Williams, first of all, who was the United States attorney that brought the case, Damian Williams, he brought the case. These 6 U.S. attorneys tried the case based on a falsified civil complaint filed in federal court. Prosecutorial misconduct. Listen to all of the hurdles that Puffy overcame, that the jury of 12 New Yorkers saw through and said, no, no. The Southern District of New York prosecutors put a witness on the stand, Brianna Bogelin, who was also suing Puffy for $10 million in a civil suit. She got on the stand and lied, perjury. Cassie got on the stand and lied, perjury. Mia got on the stand suing Puffy for $10 million, lied, perjury. Deontay Nash got on the stand, lied, perjury. Dawn Richard got on the stand, lied, perjury. Capricorn Clark got on the stand, lied, perjury. Jane Doe got on the stand, lied, perjury. Dawn Richard suing Puffy for $6.45 million. Brianna Bogelin suing Puffy for $10 million. Mia suing Puffy for $10 million. Cassie sued Puffy for $20 million. He overcame all of that. Puffy overcame all of that. A jury, 12 jurors, 12 jurors, from New York, of all different ethnic backgrounds, all different ethnicities, heard the testimony, and they looked at the Southern District of New York and they said, we don't believe you. not guilty. Set that man free. I need y'all to hit that like button, hit that like button. Hit that like button. I know it's late, but hit that like button anyway. The jury acquitted Puffy after 8 weeks of hearing all of the lies and witnessing the prosecutorial misconduct. They acquitted Puff. They found him guilty of the Mann Act, interstate, crossing the lines, interstate foreign commerce or something like that, to engage in sex. In Puffy's PSI, the probation department is asking for 70 to 87 months as a sentence for Puff. 6 years to 7.5 years. When, according to the sentencing guidelines, base offense level 14, USC 182421, section 2G1.1, criminal history category of 0, on the sentencing guideline chart, that comes in as a base offense level of 14. The sentencing guideline range for base offense level 14 is 15 months to 21 months. Puffy has sat in MDC Brooklyn for 1 full year. What's up, man? The Mets tied it up 7-7?
Yes.
What in it?
Top 7, but it was just 7-6, and they
Say
were
what's up to the people, man. Pittsburgh represent.
So yeah.
Appreciate you, Sean.
It's 7-7 now. It was just 7-6. They were winning.
The Mets was winning?
The Mets was winning. It was just. Oh, Alonso's up.
Anybody on base?
Bottom of the 7th was just starting.
No out. Base offense level 14. The sentence is 15 to 21 months. Puffy's done a year. In the federal system, every time you do 1 year of incarceration, you get 54 days of good time. So effectively, he's got 14 months already done in the hole. Puffy's lawyers are asking for 14 months. Get us out of here. The probation department this is page 23 of 182. The government accused Puffy of some heinous crimes. It branded him an evil trafficker and a racketeer who coerced and defrauded his girlfriends into having sex against their will. But none of that was true. And Mr. Combs exercised his constitutional right to fight the allegations and put the government to its proof at a jury trial. And at that trial, the Southern District of New York deployed the full force of its awesome power. For 8 weeks, it presented the best evidence it could muster to support these disturbing allegations. But it failed to prove them because the trial revealed the true facts. 12 attentive jurors heard all of the evidence. They heard the testimony of Puffy's girlfriends. They saw thousands of text messages, thousands of emails, thousands of videos, and other documents about the relationships and the events in question. These 12 citizens diligently applied the court's instructions on the law to that evidence and unanimously rejected the Southern District of New York's sordid tale of coercion and racketeering. The jury's verdict could not have been more clearer or more consistent. The jury found that Puffy is not guilty of forcing, coercing, or defrauding either Cassie or Jane, and that he is not guilty of RICO conspiracy. Put simply, the jury has spoken. But it would be unlawful and a perversion of justice for Judge Submaranian, you, Judge Submaranian, to sentence Puffy as if the jury had convicted him of the SEX trafficking in RICO, or to increase his sentence based upon the judge's own findings about force or coercion or racketeering. If you're going to do that, what is the point of a jury trial if Puffy can be acquitted but then sentenced as if he had been convicted? Yet, Judge Submaranian, the Southern District of New York Probation Office and the Southern District of New York Prosecution are asking you, Judge Submaranian, an employee of the Southern District of New York, Judge Submaranian, you an employee of the Southern District of New York. The probation office and the prosecution are asking you, the judge, to do just that. Probation, Southern District of New York Probation recommends guidelines enhancements based on acquitted conduct and the imposition of a sentence 5 times longer than the average sentence for Mann Act defendants with similar criminal histories. And then the probation justifies this lengthy sentence based on the supposed fraud and coercion that the jury rejected. So the Southern District of New York, in their proposal to the judge about the sentencing guidelines, they took the base offense level 14 and they enhanced it on force, coercion, and fraud. The jury, all of these, fraud and coercion, were predicate offenses under the racketeering conspiracy that the jury acquitted him of. Yet the probation office asked the court to sentence Puff based on fraud and coercion that the jury rejected. The probation department, when they were doing Puffy's PSI, said, yeah, we're gonna sentence him on the Mann Act, but we're gonna enhance that joint. We're gonna raise the base offense level from 14, we're gonna jack it up based on fraud and coercion. But fraud and coercion were predicate offenses under the racketeering conspiracy that the jury said Puffy was not guilty of. So what the probation department is saying, Judge Submarinian, you gotta throw that in the trash can. You gotta throw that in the trash can. Now, that's the probation department. Probation department over here. Probation department over here. Southern District of New York Probation Department engaging in misconduct, violation of Puffy's constitutional rights. Probation. The prosecution is over here. Prosecution is over here. Probation over there. The prosecution continues to engage in prosecutorial misconduct. The prosecutors, for their part, have lost all perspective. They're not even thinking clear. They have been cheating since the beginning. They are going to continue to cheat. They are going to continue to diminish and tarnish the brand of the Southern District of New York. They are going to continue to make themselves look low. The prosecution advocate for numerous enhancements. Even the probation didn't find warranted, and seek to sentence Puffy under a different enhancement for a crime he was never charged with, which would result in a guidelines range above the statutory maximum of 20 years. The prosecution want to give Puffy more than 20 years. That's even above the maximum that he could get. This is wildly out of proportion to the conduct at issue. These threesomes with Puffy, Cassie, and the male escort, Jane Doe, Puffy, and the male escort, comprised fully competent adult men and women who voluntarily crossed state lines and had consensual sex with each other. And Puffy made no money from this conduct. We are unaware of any other Mann Act prosecution based on such conduct. Nevertheless, the average sentence for Mann Act defendants sentenced under the applicable guideline 2G1.1, Section B, subsection 1, in criminal history category 1 is 12 months incarceration. And the average sentence is under 15 months, even when one includes defendants who received the coercion enhancement. So even if Judge Submaranian goes for the coercion joint, that the probation department want, under other cases, the average sentence is under 15 months. Still. Thus, probation recommends a sentence 5 times the typical sentence. And the prosecution apparently believes a sentence of 20 times the typical sentence may be appropriate. This is where we at, y'all. This is what we dealing with. I need everybody to hit that like button. Put me on 100 likes. I need y'all to put me on 100 likes. That's where we at. But I believe Judge Submaranian gave an order dated July the 9th, 2025. And he didn't ask for, he was very specific, and he was very matter of fact with what he asked both the prosecution and the defense to bring him. And that was cases with criminal history category of 1, 18 USC 2421, with a base offense level of 2G1.1. So I don't think Judge Submaranian is going to go for what the prosecution is saying. He's not. He's not going to do that. He would, number one, the case would get appealed in a heartbeat, right off the rip, straight to the Second Circuit Court of Appeals. Alexander Shapiro would be all over that. Alexander Shapiro has had 2 cases overturned in the Second Circuit Court of Appeals in the last 4 months. Puffy's case will get sent to the top of the pile and would get immediately overturned. Judge Submaranian would be admonished. I wouldn't be surprised if he was called before a congressional hearing and be asked to explain why he didn't adhere to the guideline of a base offense level of a 14 with a criminal history category of 0. This would be a stain on his judgeship, He would be ridiculed amongst his peers. He would be ostracized from competent judges. He would make himself appear incapable of administering the law as a federal district judge if he were to agree to what the probation wants or what the prosecution wants. I don't think he's going to do that. I don't think he's going to do that. I think, number one, let me say this. Today is Tuesday. Thursday, there's a hearing at the court where they're going to be discussing the Rule 29 flat out acquittal that the Southern District of New York has to prove why Puffy shouldn't be granted a Rule 29 acquittal that Alexander Shapiro filed for. That's number one. Number two, the Southern District of New York has to explain and substantiate why Puffy shouldn't get a Rule 33 new trial. This happens Thursday. Don't be surprised. Don't be surprised and mark this video. I need y'all to hit that button. Put me on 100 likes. We got 72 likes. Let me get 28. I need 28 more likes. Don't be surprised if Thursday the case is all over. Don't be surprised, because I've been following this case from the beginning. I have studied Judge Subterranean's modus operandi, or his MO, how he moves, how he does things. And when I heard that he ordered a hearing 8 days before the sentencing to talk about the Rule 29 acquittal or the Rule 33 new trial, I said to myself, this dude, Judge Subterranean, normally, if he is not going to grant something, he'll just type up a letter motion, a letter order, and say, no, I'm not giving you the Rule 29 acquittal because bang, 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 bang. Type up something else. Boom! I'm not giving you the Rule 33 new trial because of that, and that. And he would send the letter out to the prosecution and to the defense and file it on PACER. Why is he calling a hearing 8 days before October 3rd, the sentencing? Puffy is going to be there, all the lawyers are going to be there, all the prosecution is going to be there. Why is he calling this hearing when he could have just wrote a letter and said, no, I ain't going to do it? Why is he calling this hearing if he's not going to acquit Puffy? Watch what I tell you now. Y'all make sure y'all come back to this video on Thursday. Check me out. Check me out. Check me out. I'm telling you what I know. What's the score? I'm telling you what I know. And the onus, Maria from Canada, I see you, baby. Shout out to Maria from Canada over there. Shout out to Canada over there. The onus is on the Southern District of New York prosecutors who got beat, who lost, who can't compete with Puffy's lawyers. All of the questions, there's a 4-bullet point letter that he sent out yesterday. And he's asking the prosecution, y'all need to be able to come in here and prove this, and prove that, and why not, prove that, and prove that, and why not. And I'm gonna give the defense 20 minutes, and I'm gonna give the prosecution 20 minutes after we deal with that to talk about whatever else y'all want to talk about. But he specifically, Judge Summerani is specifically speaking to the prosecution that y'all got to come in here and convince me why I shouldn't let this man go home Thursday. Alicia Butler, look at my girl Alicia Butler. I need that dollar, Alicia. Thank you, baby. I'm gonna get me, I can't even get a full cup of coffee with it, but I'm gonna get the cup. Alicia bought me a cup. Now I need another $1 so I could get the coffee, in the cup with the cream. But Alicia, thank you for your $1, baby. I appreciate you. You've been supporting me this whole time. Thank you for the super chat. I need 15 more likes, y'all. 15 more. Put it on 100. Let's go. I'm at the train station. I'm in downtown Pittsburgh. Sidebar. Goddamn sidebar. 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 As soon as I get 100 likes, I'm gonna get off of here. What's the score, Sean? 7-7? Sean keeping track of the Cubs and the Mets game. Who that? The praying man. There you go. Free Puff, sidebar, the praying man, the praying mantis. I am the praying mantis. Wow! The praying mantis. Praying mantis style. I can't wait until Thursday, time, sir. Alicia Butler say, time, sir. Calm G. The judge hates Diddy. We're gonna block you because you don't know what the hell you talking about with your fake profile. Get your ass up out of here. How many days you was in the courtroom? I got 96 likes. I need 4 more. 4 more. What's the score? 9th inning? Hey, you know Jeff McNeil? He choked up on the bat. He damn near the half of the bat be down here. He be choked up. But he made contact though. What's up, Tia? The praying man. Praying mantis style. Praying mantis. I got 100 likes, y'all. I gotta go. I'm tired. Alicia, thank you for your super chat. Praying man, thank you for your super chat. Tia said smash that like button. Maria, Chicago, what up? Chi-Town, we on our way to Chi-Town. Our train come in an hour and a half. We gonna leave Pittsburgh. We get into the Chi, 8 o'clock tomorrow morning. Gonna be in the Chi, man. Nigga gonna be in Chicago. Check me out. Gonna be in Chicago. Gonna be in Chicago. Check me out. Gonna be in Chicago. Y'all think I'm crazy, don't you? Y'all say that nigga crazy, ain't? Yo, my 2x4, hey, where my man at? King 24. King 24. I got the old 2x4 out the garbage over there. I got my 2x4 from over there. My 2x4 was in the back of the dumpster. All kind of stuff was on top. It's got dents in it. It been in the rain. It been in the snow. It been in the sleet. It been in the hail. But it still stood the test of time. My 2x4 better than the new one. I don't even want no new 2x4 because it's untested. It might fold up. But my shit old out the garbage. You know, my 2x4 tough. My 2x4 money. Free Puff. Alicia, thank you. Get that money clean. That clean money. Get that clean. I ought to get some money right there. Get that clean money, man. Get that clean money. Check me out. Check me out. So that push-up's clean, man. Look at that picture right there. My push-up money clean, man. All right, y'all. Peace.